international. I go to have clients in Europe even. And okay, is everybody there?
Wallace, did you just drop, or was it on our end?
Yeah, I don't know. It just said the internet connection kind of was shaky, and then it came back. So I
Okay,
guess
got it.
everybody's there.
Seems like we're back on now.
Again, I don't know if it's the storm or whatever, because the router isn't too far from here, so I should be okay. So again, my name is Wallace Collins. I'm an entertainment lawyer based in New York, but I have clients all over U.S. and in other countries as well. Some in Germany and Barbados and UK and wherever, Hawaii, wherever you can think of. And just like with this webinar, you know, these days everybody is connected everywhere. So, but I'm based in New York, and that's kind of where I operate out of for the most part. And I represent a lot of songwriters. I also represent publishers and producers and others, but a lot of songwriters. And so I'm going to talk a little bit about the basics. You know, I'll kind of go through the basics of need to know stuff for every songwriter. So the most important thing, I guess, is you start with the copyright. When you fix your idea in a tangible medium, you've created a copyright. And depending on the country, US copyright law has a registration process, some don't. But in general, most copyright law says when you fix it in a tangible medium, so you do something more than think it or just say it. You record it, you write it down, you videotape it. Fix it in some way, your expression of that idea is your copyright, and you own 100% of it. As a songwriter, sometimes people think, well, now I need a publisher because, you know, in order to somehow own my whole copyright. But that's not the truth. When you create it, or you and your partners create it, you own 100% of the copyright. You've created this thing. In the music field, there's two copyrights, one in the sound recording and one in the song. So when you as a songwriter write a song, you've created a copyright. If you record it, you've created another copyright in the sound recording. Someone else could record it. Another artist could record it. You've still got that one song copyright, but you've now got a second sound recording copyright. And for some songs, you know, for instance, Yesterday by the Beatles, thousands of people have created their own sound recording of that song, but the songwriters and the publisher of that song still own that original copyright. They get the songwriting and the copyright money for the song, and we'll get into money in a second. But all those different recording artists, whether it's Dean Martin or the Beatles or whoever recorded it, they generate their own money from their own song copyright. I mean, from their sound recording copyright on that original song copy. The sound recording is the artist's royalty. He gets his money or she gets their money that way. The songwriting money kind of breaks down into several sources. One of the main ways that a songwriter makes money from his copyright is mechanical royalties. Mechanical royalties, again, it goes way back to piano rolls when they used to be in pianos, but then from vinyl records and CDs, and now we have streaming. But the bottom line is when a recording of a song is sold or transmitted or streamed, downloaded, some amount of money that's paid goes to the songwriter. Some money goes to the record label and the artist, but a certain pennies or a percentage of the money, again, each streaming services and YouTube are different than downloads on iTunes. It's different than the way you used to sell CDs. The bottom line is it all comes out to be some amount of money, and we'll refer to it as mechanical royalties, goes to the songwriter every time a song is streamed, downloaded, sold, in effect. Its copy is made and sold. Now, that's one area. Another area that a songwriter also gets money from is, we're back, okay. Performance rights. I'm watching my monitor to make sure that I don't cut out. Performance rights is mainly from the radio, but also if your song's in a TV show and gets broadcast on television. In the U.S., they don't pay for movie theaters, but in other countries, if your song is in a movie and you play it in a movie theater, that's called performance rights. If they play your song at a baseball game or a football game at a stadium, and so for that you need to join a PRO, which is a performing rights organization. In the US, we have several. We have ASCAP, we have BMI, we have CSAC. In the UK, you have PRS. In Germany, you have GEMA. Every different country or territory has their own performing rights society or multiple societies. You join one of those, it's a membership thing, and they will collect your performance rights for the radio, television, stadiums, depending on how big you are and how big your song is. They also will collect money from live performances in venues. So for instance, if you're a member of BMI and you play the bitter end in New York City, you can go, you set up a profile on BMI as a writer and your own publisher, because initially you will be everything. And you list your songs one by one. And then if you play the bitter end, or anywhere, but I'm just using the bitter end as an example, you play a venue that's licensed by BMI, you can go onto your profile, you can list that last Tuesday I played there and I did these 5 songs. And then a couple months later, you played a different venue and I played these 2 songs. And gradually you will actually get money from that because they license all those venues that have live music. So obviously if you're playing in a stadium or an arena, you're going to get a lot more money than if you're playing in a small club or bar, but they still pay something. And in this day and age, every little bit helps. So you have the mechanical royalties from the copies that are made. You have performance monies when your song is performed in some way or other. And I mentioned TV and radio. For mechanical use, it's usually just a compulsory license. So after the first recording is made and released, it's an automatic rate and it's an automatic thing, and it gets kind of complicated. But what it really means is once you release your first recording of the song, whether you do it or you let someone else do it, then anyone else can record that song as long as they pay the set mechanical rate, which is like 9.1 cents for a vinyl or a CD recording. It's about the same for a download. It varies, and it's much less for streaming and different other things, but there's a fixed percentage or penny count depending on the media and the medium it's going through for the sales and the downloads and the copies. Then for performance rights, it's all very vague, but it comes from the Performing Rights Society. Another way to make money is if a recording gets licensed into a TV show or a movie or a commercial or a video game. And that's what's called a synchronization license, because they're synchronizing music with a visual image. Usually with games, there's no performance right because they're not going to play the game anywhere in public. I mean, they are, but they're not. They're going to pay a one-time sync fee to put that song into the video game. But for film and television, the beauty of, say, television is the best example. You'll get a fee, a sync fee when you sign the sync license to put the song into the TV show, a fixed amount of money, on the day you sign the contract. It could be thousands, it could be $100, whatever it is. But then when they play that TV show on a network or on a cable network, you're going to get more money from your PROs. So everything kind of feeds together for the songwriter, and you'll get money from the sales and the streaming. You get money when it's synced into the TV show. Then when this TV show airs, you'll get some money, and then maybe people will Shazam the song on the TV show, and they'll go to the streaming service or Spotify or Pandora, wherever they use, and they'll get the song. So as a songwriter, it really can feed on itself, and it generates not as much as, but a good chunk of money. Um, again, using the Beatles as an example, since John and Paul wrote most of the songs in those days, they used to say that John and Paul were about twice as rich as George and Ringo because of the songwriting money, just about doubled the amount of money that the group made from their recordings because of the songwriting. And then for the copyright, the length of the copyright when in America is life of, and a lot of countries are through treaties have the same amount, and it's life of the author plus 70 years. It keeps getting longer and longer, but it's life of the author plus 70 years. So if you write a song when you die, for 70 more years, that copyright's in existence. There's one exception, one exclusion, which is there's a 35-year reversion right. So if you write a song now, even if you sign a contract, and we'll talk about contracts in a second as kind of the final thing to be aware of. If you sign a contract now that says you're giving the publisher the song forever or for the life of the copyright or whatever it says, regardless of that, in 35 years, you can contact that publisher, you send them a letter and you file a copy in the copyright office and you say, I'm giving you notice that I want my copyright back after 35 years. For older songs, pre-78, it's 56 years, but again, that won't apply to most of the people we're talking to here today. So if you write a song, even if you sign it away for life, 35 years from now, if you follow the right procedures, you're allowed to give notice and get the rights back to the song. The idea being that whoever you are now when you make your first deal, 35 years from now, if that song still has a value, it gives you a chance to get a second bite at the apple and make a better deal. So when they extended the copyright length of the copyright from 50 to 70 years back in 76, they decided to put that one carve out in. That's one reversion. Again, I don't want to give you too much information too fast. I'm just hitting on some of the kind of issues that may come up just so you're aware. So we have the copyright in the song separate from the other things. Life of the author plus 70 years. If there's two authors, it's the second author plus another 70 years. And then we'll talk about contracts, because one thing that the copyright law says is a copyright, because you have a registration system, particularly in the US, but a lot of countries, you can file a registration. So, and I recommend you do that because it makes sense, because you own the copyright from the minute you fix it in a tangible medium, but how do you prove it? And there's some additional benefits, particularly, I usually recommend to clients, before you load it up to YouTube, before you put out your CD or put it on a streaming service, make sure you register the copyright. You file the registration. It may take a while to get back confirmation, and you can do it online. You can upload an MP3 these days. It's very simple. And that gives you protection. It's not only proof in a court of law in case you have to sue, but it also, if you prevail in the lawsuit, you get your legal fees awarded, which can be a big part of the problem and the expense in any litigation over lawsuits. So in the event, and it's rare, but it happens, that your track gets sampled or your song gets, copyright infringement occurs, it does, you'd have this extra leverage of having your legal fees paid, which may help you make a quicker settlement of your case rather than dragging it out the full length. So I recommend that before you distribute your music too far, if you're working on demos, if you're just showing it to friends, that's a different thing because it isn't widely circulated beyond your circle of friends. But once you get putting it on YouTube and whatever else, then you really got to start thinking about, all right, people that I don't know are hearing my song and sharing it with other people I don't know. And, I should have that registration just as a protection. And like I said, it's a very cheap insurance policy. I think it's about $35 or $45 in the US these days. And, if your song happens to get infringed, it's going to be really helpful to have that in place, way in advance. And then the final kind of thing to be aware of is signing contracts. The copyright law says that you own the copyright from the moment you fix it in a tangible medium, you or your co-writers, but you can only transfer it in a signed writing. So a handshake deal to give away your copyright isn't going to work. You can't bet it away. You can't handshake it away. You can't barter it away. but you can sign it away, which is a reason to be very careful of what you sign. Now, there's all kinds of agreements. I mean, you may have an agreement with your co-writers. If you're co-writing and you're sharing it all equally, it's not as necessary, because the courts generally say if there's a song written by 2 people or written by 3 people or written by 4 people and they're sharing it equally, you don't really need to have a written agreement. That's what we, the court, would enforce anyway. But if you are writing with, say you're a famous person and you're writing with a lesser writer, you might make a deal, or an artist writing with a lesser writer might make a deal that says, look, I'm Harry Connick or I'm Bruno Mars, so I get 80% and you get 20%. Even if you wrote more of the song, we have a signed writing that says we have a deal because I'm who I am and you're an unknown. I'll give you a shot, but I'm going to get more of the money. And look, that's the trade-off you make. If you're getting a song on a Whitney Houston record, or got a song on a Whitney Houston record, or say a Mary J. Blige record, or a Bruno Mars record, you might be willing to agree to give that person, as a co-writer, if they're a co-writer, a bigger percentage of the song. So those are collaboration agreements. I mean, it's important sometimes to have them and also to be aware of them. I mean, sometimes a producer, I've had scenarios where a producer is going to produce the demo of your song, but in the course of doing it, maybe he plays a couple piano chords differently, or he adds some drum beats and he produces it and makes it sound different than the song you sang on one guitar or you sang a cappella. And producers will say, well, I want a piece of the song. I co-wrote the song now. My recommendation is that's not the deal. The words and the melody is the song. If somebody changes some chords or changes the arrangement or says, like, let's do the bridge, 2 choruses at the end, or open with a chorus instead of the verse, that's not necessarily writing a song. That's just rearranging what's there, and that's part of the job of what a producer does. So again, my recommendation is approach with caution. It's always a leverage to who's got more power and whatever, but my recommendation would be, as a songwriter, be a little bit protective. You don't want to be paranoid, but you want to be aware that, hey, look, I'm writing, maybe I do lyrics, someone does music, or maybe I do all myself. Now I'm getting into the recording stage. Well, I'm not automatically going to give a piece of the recording to the people that I, work on the recording with, because what happens if I make a recording and I don't like that recording, and then I have to go to someone else to make a recording, but I gave him a piece of it, and now I got to give the other guy. So you'd run out of pieces. So my recommendation is to try to, just be aware of that as well. You only have 100% to divide up, so you mostly want to divide it between your writers. You may split it equally. You might split it unequally. It doesn't have to be complicated. You could draw on a napkin. You could draw, a circle on a napkin and go, half or quarters, and put your names in the little thing and sign it, and you got a deal. That's the evidence you have of how the song was split. Usually the splits between the songwriters is less of an issue. The bigger split is when people start making contracts with other people, producers, publishers. Now, what a publisher actually does, and I'm going to give you the basics so that we can get to Q&A and discussion. But one of the things that on my website, and it's just my name, wallacecollins.com, there's an article that's entitled, "What is a publishing deal and do I really need one?" Because a lot of times you'll hear people go, well, I need a publisher, or publishers will say, you need a publisher. And yes, okay, maybe, but the truth is, you as a writer, when you've written the song, and nowadays when you can record it yourself or with a producer record it and then upload it yourself onto YouTube and Spotify and wherever else, you're really your own record label. You're your own publisher. You're doing it all yourself. You don't want to necessarily sign a deal with just anyone that says they're the publisher, because what that really means in most cases is you're giving them a piece of what you already own. And that's very important to be aware of. In other words, you own 100%. You do a deal with a publisher, you may be giving them 50 or 25% of your song. It's not necessarily bad. You can negotiate a fair deal. If you're doing it with Sony or EMI or one of the big publishers, they're going to pay you a lot of money. Or they're going to hopefully pay you a chunk of money, and they're going to help you collect the money, because when the song gets out there and becomes something, you have to figure out how to collect all the money from the places, and they have the leverage and the connections to do it. What they usually don't do, what they always tend to hint that they do, is help you get songs recorded and help you promote yourself. And the truth is, these days, that's very rare. Publishers tend to function more like banks, and they really they're really in the business of collecting the money that's out there that's already being earned by your song. So you may find that no publisher's interested in you anyway until you co-write a song that's, say, on a Bruno Mars record. Then suddenly all these publishers are going to be coming running around saying, I want to get, hey, let's make a deal for your 50% share. Why? Because there's money out there and they know it, and they can make a deal and advance you some money, basically give you your money in advance to induce you to sign a deal with them. So take a look at that article that explains, like, what is a publishing deal and do I really need one? Because it kind of breaks down the different kind of deals that there may be. Publishing deals, administration deals. Do they own the copyright? Do they own part of the copyright? Do they just administer the copyright and you retain the copyright, but they'll collect the money and get a commission? Because it's a combination of things. It's money. It's not only how much money you get up front, but how you split the money. So keeping in mind that every dollar that comes in would be coming to you. If you make a deal with someone to collect your money for you, some amount of that dollar is now going to them. Some amount of the copyright might be owned for them. How long? Is it forever? If you do a publishing deal for 3 years and you get one song recorded, do you get the other songs back? Or do they keep all the songs you wrote during that 3 years? I mean, these are the kind of things we negotiate when people have publishing deals and production deals and whatever different kind of deals come up for songwriters. Usually we want to say the most amount of money up front and the least amount of stuff that we're given for the least amount of time. You know, we might have to agree that if a song is recorded and released during this 2 or 3 or 5 year period of time, then yes, that song stays with the publisher forever. But if I wrote 100 songs during that 3 year period and none of the others got recorded, then I would get them back and I could go do some other kind of deal with them. So again, I hope I'm not going too fast over too many esoteric issues, but that's the kind of things that you try to negotiate in a contract, because you as a songwriter, hopefully you're very prolific and you write lots of songs. But each one of them is, songwriters say to me, each one of them is like my baby. So I might like one more than another this week and some different one next week and, you know, whatever. But I don't want to give any of them away for free. So I would, again, series in my article on, you know, what is a publishing deal and how do I really need one? And it's www.wallacecollins.com. And there's some other basic articles there too about songwriting and publishing. But that's one that's a good primer to kind of see the basic issues that might come up in doing a publishing deal. But even if you read this article, I would still recommend, my advice always is, don't sign anything other than an autograph unless you have your lawyer look at it first. So you're meeting me tonight, that's one lawyer, but there's other lawyers out there. You want a lawyer experienced in the entertainment business who does this all the time. Because the advantage there is, just say, for example, a client hires me. He's got one publishing deal or one management deal or one production deal, whatever it is. He's got just that one. He only sees that one. He's maybe never done another one. I've been doing this for 30 years, so I've seen hundreds of them, right? And they're all over the place. There's a range. There's not yes or no. I mean, you know, there's all these, you know, it might start here and we get it back to here, or it might start here and we get it back, you know, we try to get some things to make it fair in the end before you sign it, fair enough that you'll do it and they'll do it. But you still want to have someone who's seen a lot of these deals sit with you, or nowadays Skype with you. Sometimes clients, if we do it by phone or Skype or email even. But to say, look, here's this provision is good and that provision is not good for you, and here's why, and here, this is the kind of thing we do, but this is what we do on a different day. So, you know, if we have some leverage, we can get you more of this, and let's give them less of that. And again, it's hard to be too specific, but that's the concept, is, you know, that the lawyer's job is really to represent you and try to get a more fair deal for you. Fair is a relative term in any business, but, you know, you want to make it better for you than it was when they handed it to you. That's really the concept here. You'll hear the expression sometimes, oh, this is a standard publishing deal, this is a standard production deal, this is a standard songwriter, whatever. Again, that's just a word that's a red herring. It's meant to distract you. There's no actual standard. Yes, generally there's a copyright owned by the songwriter, and a publishing deal talks about what percentage of that copyright is given to or licensed to the publisher, and for how long and for how much money. But other than those basic concepts, and they're concepts more than standards, every deal is different. You know, for a big artist, for a big songwriter, for a new songwriter with a big hit, I can get a whole bunch of different terms than for a songwriter who's kind of got nothing going on and wants to, you know, try to get help from a publisher and maybe some money up front too. So again, every situation is different, but my advice is, you know, be careful of the contracts because they tend to, particularly if someone hands you something to sign, the odds are that it's better for them than it is for you. It doesn't mean anyone's dishonest. Just remember, it's a business. It's the music business. It's not the music. It might be all about music for you. It's all about music to my clients and the songwriters and the producers that I work with and the artists. But at the end of the day, you know, one of the things I help them with is to be aware of the business side. They don't want to think about it. They don't want to worry about it. They don't know enough about it. But I think of it this way, you know, it's good to inform yourself as much as possible about the basic legal rights of songwriters or producers of who, you know, whatever it is that you do as an artist, because you need to communicate with the people who are going to give you advice, whether it's lawyers and accountants and managers. And then if you make a record deal or a publishing deal, you're going to communicate with those people. And you need to kind of know the lingo. So there's no harm in knowing what an advance is, what a performing rights society is, that a mechanical is a way to make money, that a sync is a way a songwriter makes money. It's your business, so you need to know the lingo. But it doesn't mean you need to be your own lawyer or do your own job. Or do that job yourself. I mean, here's an example that I've used. So say you're going to go get brain surgery. You might be curious about what the operation will be. So you go on YouTube or somewhere and you look up or you get a video about how to perform brain surgery and you watch it. So now you see what it is, but it doesn't mean you're a brain surgeon and you should now go try to perform brain surgery. It just means you know the lingo, you kind of understand the concept of what's going to happen. But what you would do if you were smart and needed a brain operation was you'd go find the best brain surgeon you could with the most experience to operate on you. So it's kind of the same thing in the business world. You know, the big shots have the big lawyers, but there's, you know, whether it's real estate or whether it's banking, whatever business it is, you know, there's always lawyers that know that business. Entertainment business, the same thing. There's enough lawyers out there. It's a smaller business than others, but there's enough lawyers out there that have the experience and know what they're doing, and, you know, can help you sort through some of those problems. So, like I said, keep in mind when you make a song, when you create it and fix it in a tangible medium, you own a copyright. That's an asset. And a house is an asset, a car is an asset, you know, money is an asset, and your copyright is an asset. It may have no value initially, but eventually it could have a lot of value. So you want to protect the value of that asset. And the beauty of it is it's what they call intellectual property. There's not really, you can't see it. Yeah, you could write it down on a piece of paper, but that's still not it. You could write the notes, that's still not it. It is when the music is played and you hear it. So it's an ethereal thing, but that's what we say. We refer to it as intellectual property. It's not real property, which would be, you know, real estate. It's not personal property, which is money and cash and cars and things. It's intellectual property. It's created from the brain, and it really isn't visually, you know, it's emotionally experienced. So when you write a song that connects with an audience, it's not because they see it and enjoy it. It's really because they hear it and the sound affects them. The words and the melody combined with the chords, it makes them feel an emotion, either excitement or sadness or whatever it is. And your job as a songwriter is to facilitate that. But it's property. There's a value. It's a copyrighted, and you want to, like I said, not be paranoid, but you want to be protective. You want to be smart. You want to be informed. So those are my, you know, basic highlights, tips of the basic things to know as a songwriter. So if people have questions about any specific thing, I'll move the keyboard down here so I can answer some questions and repeat some questions. So let me see. Okay, I guess you can see all the questions, but just to be clear, I've registered my melodies and lyrics with copyright.gov, right? So that's the US copyright, as sound recordings with lyrics. Tunedly has added music to my songs. I now register the works, mastered MP3 file separately as a sound recording with lyrics with the same song name. And that's fine because, again, like I said, there's a couple things. One is the song is one copyright and the sound recording is another copyright. So, and you may change the song. So you may have one version of it. And then when you record the second version of it, not only do you have a new sound recording, which is also a new copyright, but maybe you've added a bridge or you've changed some lyrics or you've changed the melody. So there's no rule against you. Nothing limits how many times you can file a copyright under the same song name. And I'm guessing there's probably a lot of same song names out there, even as it is. So that's not an easy. Okay, let's see. Someone said they lost the signal, but mine's saying on air, so I'm still seeing. Okay, so CD Baby as a publisher, to be honest, I don't know a whole lot about what they do as a publisher. My understanding was that they just administer the publishing, which means they collect the money for you. So in effect, if you do a deal with CD Baby, you own, and I may be wrong, I'd have to see the contract that you signed, but the ones that I have seen, my understanding was you are the owner of the song copyright and the recording, and you make a deal with CD Baby to distribute your music, and you give them the song as part of it, and they give them the song. You license them the song as part of it, and they collect the song money, the mechanical monies, maybe the performance money, and they pay it through to you. They may charge a commission, 5 or 10 or 15% for collecting that money for you, but you retain the copyright. And if they don't, that's what you would want to do. For anyone who's not a real publisher like that, any company that's an intermediary, you want them to collect the money and pay it to you, and then you're the publisher of your own song, and you'll collect it until you get a Sony or an EMI or some company that's really a publisher. The myth about sending the song to yourself. It's here's what it does. It proves, and again, when I was a young songwriter, I did it, and it doesn't mean you can't do it. What it shows is if I write a song today and I send it to myself and I keep it sealed in that envelope and it's postmarked March 7th, 2018, I can prove, it's proof of a sort that in a year or two from now, when it gets infringed, that I did create it, if it's challenged whether I created it or not. The problem is the copyright registration system is so much of a better system. Because if you file the copyright registration, and again, you can do it online with an MP3, however, it's fairly simple. You could do it for your song while we're talking on this, open another window and go on to copyright.gov and you can do it. It's when you get that registration certificate, it's what's known as presumption of validity. So when you claim that you own a copyright, that registration form is legal proof that you can enter into court, and it shifts the burden to the other side to then have to overcome that proof, and they'd have to prove that somehow they had the song before you. So the registration system is much better than the mailing it to yourself system. Now, if you're really, really broke and you don't have any money, even
Hey guys, can you hear me? Hey everybody. I guess you can hear me. Wallace is in New York. They having a huge storm today, so his internet was kind of shaky already. So I'm guessing that he dropped out, and let's wait for a few more minutes and see if he's coming back. If not, we're just gonna cut this short. And if you have any questions, just shoot us an email as usual. Thanks, Andre. Oh, Wallace is back. Awesome.
I'm sorry, guy. You know, you saw that power. You saw it go out, right? You hearing me now? I'll make sure it's on. Audio says it's on. Hopefully you're hearing me. Well, anyway, it went out. I think you saw behind me the power went out for a second. Luckily, it kicked back in. Maybe a branch shook a wire. I don't know how it all works out there. We're having a big snowstorm up here, and it was very wet earlier, so the trees are very caked, and now there's more snow and more wind, and the trees are a little shaky. So um, hopefully, so we'll continue on and do some more questions. I think the one we were just talking about was why registering is better than mailing it to yourself. I mean, again, you could do it that way, but for producers, people who do a lot of tracks, or even songwriters who write a lot of songs, rather than do every single song, you could put, there's no limit, you could put 10 or even 20 songs on a CD and submit it that way. Online, they pretty much make you do one song at a time, unless you can prove that it was released as a grouping, as an EP or whatever. But if you do a physical copy on a CD, you know, producers just, I say, number your track or give it some way to refer to it, put them all in there, and the ones that matter, matter. But again, for $45 or $35, depending on exactly, or a little bit more if you send it physical, I would recommend that you do the copyright registration. Again, only on the songs that you're really getting out to the public. So you might write 20 songs, you might record 2 of them, and you might only put out 1. Well, register that 1. The other ones you might come back to and play around with them and re-record them or whatever, and eventually release them. But you know, I think you know, it's just safer. I know it's unfortunate you have to pay money, but I don't know how else they would do it, and I think it's a good way to do it. So I'm trying to see if anybody else, any other questions? Because I'm, you know, I'll answer whatever else people can write there. Music libraries. Okay, so music library. These are the companies that collect a lot of music, and then what they try to do is they license it for the sync licenses, usually for film, for TV, video games. If it's non-exclusive, and again, I was just talking to a client about this today. It's better if it's non-exclusive, because this way you can make that deal with this party, and then you can make that same deal with 3 different companies, and they're all working for you. Usually what it'll say is, you give us either specific songs, and this is what I would recommend if you do a deal with a library. Maybe you just give them certain songs, 5 songs, 10 songs, 3 songs, rather than all my music, here you go, even if it's non-exclusive. Because it's harder to keep track of, and you don't know what they're going to do. So maybe you go, look, here's 5 songs or 10 songs, even 1 song. And I'll give it to you non-exclusively for a year or 2 or 3 and see if you can do something with it. And then if you can, we've got a deal. And I can do it non-exclusive, which means you can do the same deal with multiple people. That's how I would recommend best you can to deal with it. Non-exclusive is better than, you know, being signed to just one company. But again, the problem is if you give them all your songs, if you're giving all these people all your songs. Now, as far as who owns the copyright or the publishing rights, and again, just to be clear, copyright is the right, and then the business of the song copyright is the publishing of the music. So you as a songwriter are a publisher too. Publishing is generally the word we use to talk about money, the business of the song copyright. So that's where you need to be careful of these agreements. I mean, what does it say? What you want it to say is you have the right, library, to use my music and try to place it. After 2 years, 3 years, 1 year, whatever the deal is, I get it all back. Unless you place the song, then maybe I, the writer, will agree that if you place the song on a TV show, you do own the publishing rights, or we co-own the rights, or you're the and that's fine. But if it's not that, you need to be careful. And then someone says, I recommend BMI or ASCAP. There's also CSAC. There's a couple of other performing rights organizations now. Each one of them will tell you that they do the job the best. Each one of them will tell you they're better than the other. And I like them all. They've all done good for my clients in different ways. BMI, ASCAP, CSAC. Irving Azoff has his own company now. He's got some big writers, and they're doing performance rights. My recommendation is, you can sign up with one for 2 years, and then if you don't like it, you can change. So pick the one you like the most, or pick the one that, maybe your favorite star or favorite songwriter is on. If it's BMI, join BMI. If it's ASCAP, if it's CSAC, join CSAC. And in 2 years, you don't like it, you can switch to a different one. Most of them, what they say is if you have a co-writer, if you have a BMI writer and an ASCAP writer, and the ASCAP writer got more than the BMI writer, the BMI writer goes to BMI and shows them that, and BMI will equal the amount of money. So they try to all be on an equal footing. I'm from Canada. Should I register my songs in the US and Canada? I don't know that you need to register in both places. I believe there's a registration system in Canada. I've had a couple clients up there, and if it's a very similar system to the US, you don't need to do both places, really. You just register in kind of your home country, and that's the best place. The mail registered thing to the Copyright Office. Again, with the Copyright Office, you can do it online now, so it's pretty easy. In fact, it's less expensive if you do it online. They charge you more if you mail it in. So it's a bit of a difficulty there. Again, if you write 20 songs and you put them on a recording CD and you send it to yourself, and then you only register a copyright in the actual one that you're putting out to the public, or two, or each time you put one to the public, that would be the best way to do it. Does posting, registering your songs on your website or Facebook page provide copyright protection? Well, the copyright, again, like I said, the copyright accrues when you fix it in a tangible medium. So when you recorded your song, you created a copyright, and you own that copyright unless you sign it away. So by putting it on a website or on a Facebook page, you haven't altered the situation vis-a-vis you and the copyright protection. You just published it. And generally the copyright law says that you should register the copyright within 90 days of when you publish the song. Otherwise, if you don't, then you may not be entitled to legal fees and court costs and things like that. So the idea is, when you publish it, so in the old days, publishing used to mean, put it on a record and actually do something. Now it's so easy to publish, you need to be careful, because you can publish it by putting on your Facebook page, and it starts that clock running. So again, whether it's a website, Facebook, YouTube, wherever you post something, I usually recommend clients, when you do that, when you put it up really for the public, you would want to register the copyright at that point. Okay, Harry Fox Agency, what business is that? They collect mechanical royalties is what they do. So we talked about performance rights. They collected mechanical royalties. Now CSAC has bought the Harry Fox Agency. So CSAC can do both mechanicals and performance rights, which they claim is a benefit, and they're trying to be worldwide. So you would join CSAC and they'd get your mechanicals and your performances collected for you. It's early in the game work. I mean, I agree with the globalization concept of music, and some people may disagree, but the world is becoming globalized, particularly in terms of music business for sure, and a lot of other businesses too. So that could be an advantage, and you may find the other performing rights societies trying to do something similar as time goes by. Notice the Copyright Gov has closed 10 of my cases, but only sent a letter to me about one of them, which was registered way later than the other songs. Is this a problem? That's hard to say, because I don't know the specifics of the situation. Usually when you register the copyright online, you get something that you can print out right away. You get an email that says, okay, we're processing this song, and at the very least you have that. And there might be a way to contact the copyright office and ask them. There's probably a phone number. You go on the copyright website and maybe look it up. And there might be a way to ask somebody there why you got back one, only got one copyright and the other 10 didn't happen. Again, there's a step process. So first you fill out the information, then you pay the fee, then you upload the song. So if you missed one of those steps, then they might have closed it, but they probably would have emailed you and told you what the problem was. So I do have one more. Are royalties really collected from all over the world? Oh yeah, musical directors. Yeah, he's the guy that did Justin also does Madonna. So the one guy's on tour with Taylor Swift, and the other guy is was just doing something with Madonna. He did Michael Jackson's Soleil show in Vegas. That's a it's almost like a producer of a live show. These guys were record producers and musicians, but the live thing has become, live concerts for a lot of artists are really like a Broadway show. In the old days, you just had a sound man and, the band got up and played a set list. Now there's all kind of theatrical stuff, and even if there's a band playing, some of the music is pre-recorded and programmed, and it all has to be synchronized with the lights and the dancers. So these quote unquote musical directors are really the guys that coordinate to make sure that the music the band is playing the right music at the right time, and the right stems come in to play along and fill in the other stuff that you want to hear in your brain from the record, but you're not going to hear it with 5 musicians on stage. So the keyboard player, who may or may not be the musical director, has keys that he pushes and fills in all those sounds. But performing rights societies collect the money all over the world. So ASCAP, BMI, CSAC, PRS, GAMA, they will collect. So if you join one of those and you register a song, they'll collect the money from all over the world. The US money comes in quicker, maybe like a year later. And then the overseas money comes in maybe 2 years later. But yes, they will collect the money worldwide. On the mechanical side, it's not necessarily true. On the mechanical side, if you put out a record, say on a Bruno Mars record, and say, I don't know if he's on Universal, maybe, or Sony, whatever he's on. So he puts out a record, and the record goes all around the world. The record label is only going to pay you the mechanical royalties. It gets a little tricky to explain this, but the record label is only going to pay you the mechanical royalties from the US sales of the record. They don't collect the overseas mechanicals, because those other countries, they pay it into their organization, and that'll filter through to you. So for that, you might need an administrator. If you really had a worldwide record that was going out through a third-party record label, if you're the artist and you put it on through DistroKid or TuneCore or CD Baby, then you're probably getting all the money because you are the record label. When you make those deals with them, you're giving them the master of the song and saying, put it out and collect all my money. So each situation is a little different. But yes, the performance money comes from all over the world, and the other types of money potentially do. Again, each time you have to kind of figure out what the situation is. It comes back to the contract. When a client calls me up, a new client, or someone emails me or contacts me and says, I have a situation and what's going on, I always say, if you signed a contract, first thing you got to do is send me the contract. Let me read it, and I'll tell you what your situation is, because the contract is your law. You know what I mean? That there's a copyright law governs until you sign a contract concerning your copyright law, and now the contract governs. So anytime you sign a contract, you have to be aware that that's your new rules of the game, and the contract interpretation is what the lawyers have to deal with. So depending on how you set up the distribution of your label, that's gonna kind of deal with all the rest of that stuff. So let's see. Next one. It's the most common mistake that songwriters make regarding legal rights to their music. Signing contracts, probably. Signing, a producer says, I'm going to make you a star. Again, I don't know exactly what they say, but whatever they say to the songwriter and the artist, I'm going to make you a star. Sign this deal with me, and I'll put you in the studio, and we'll make records and blah, blah, blah. And then maybe the artist doesn't get a lawyer, or just thinks they know what they're doing, or they're so excited and they sign this deal. And the problem is that the deal might say you have to make 5 records for me before you get out of this deal, or even 3 albums. But it doesn't say he has to pay for the album, so you'd have to go pay for making the records, and then he'd own the records, and he's your publisher, so that he owns the copyrights in the songs for 2 or 3 or 5 records worth of music. And that's a career wrecker, because if you sign that deal, even if you didn't understand it, that's your deal. Like I said, the one thing that the courts, particularly in America, but almost everywhere, do, they don't rewrite the agreement to say, here's what you should have done. What the courts do is they look at the contract and they say, what does this contract say is the deal? If it says that the deal is you gave all your songs to this guy and he gets 90% of the money and you get 10% of the money and you have to spend all the money making the records, well, that's what it says. So if it's vague, it might help you. But if it clearly says that's the deal and it's a horrible deal, the courts don't make judgments about whether the deal was good or bad. That's a business deal. Like I said, it's the music business. You made a bad business deal. Billy Joel did it years ago. A lot of artists have done it. You've seen them on those shows. Where Are They Now? And that's what happened. They made bad deals. So that's the biggest mistake I think that songwriters make, is that they sign contracts that give away too much too early for too little, and that maybe they put out their songs without protecting their copyrights, and they make a deal with the producer that gives them half of the song copyright just for producing the record. Those are but again, it's all usually contract related. Those are the mistakes. The C in a circle signed for copyright. In the pre-76 law, it was required. You could invalidate your copyright if you didn't put that C in a circle. But the truth is, since 76 till now, it's really just a notice provision. So there's no rule that says you have to do it, but most people do it because they want to do it. They want to put the world on notice that, C in a circle, Wallace Collins is in 2018, so that if someone hears that song or whatever it is, they'll come back to me. They'll track me down and say, all right, this is the songwriter and I want to talk to him. So legally, it doesn't, the intent issue isn't really relevant anymore. Like I said, in the old days, you could potentially lose some copyright protection if you didn't put the world on notice. But from 76, which is the law went in effect in 1978, it's not a requirement anymore. So you'll see it everywhere because everybody wants to put the world on notice, but it doesn't have any legal significance other than to tell the world who you are and where to find you if they want to do something vis-a-vis the record. College student, new artist, received his first contract, but it seems if no compensation for me, I've seen so. Is that normal for contracts? What can I do to find the kind of information out? Well, like I said, my rule is you don't sign anything until a lawyer looks at it first. You can contact me through my website and we can talk. We can take a look at it and see. I mean, anybody who's on this webinar, I'm happy to at least give you some basic free legal. I mean, just to look at it and tell you what it is. But yeah, if you're not getting money, then why would you do a deal with anybody? I mean, think about it this way: if you're selling a car, it's sometimes in the music business, we're so the artists are so close to it that they have a hard time making a neutral decision. But think of it this way: say it's your car, or say it's your house, or anything, piece of property, and you're going to sell it to somebody, and the contract says you don't get any money for it. Well, that's not a deal you would do. So why would you do that deal with your songs or your recordings or your rights as an artist, right? So usually, I mean, every deal is different. It might be a finder's fee. It might be something where they say, look, give me 6 months or a year and I'll get you a record deal. And if I do, I get a percentage, or I'll try to get you a cover song, get someone to record your song. And if I do, I get a piece. Fair enough. Again, we got to see what the paperwork really says, but that could work. But if it's a record deal where you're signing over your rights to all your recordings for this year and next year and the next year, and they're not giving you any money up front to even make recordings of those, I'm just not sure what it is they would do. If there's no compensation for you, if there's not some money up front, then why would you sign the contract? You own 100% of the copyright now. You own all the rights in the recordings you make, and the songs you write. So unless somebody's, again, they got to make you a deal you can't refuse. It's got to be, wow, you're going to give me $50,000 to record in a studio, or you're gonna find me a big producer and pay for the recording and give me some money in my pocket so I can pay my rent. All right, that's a deal. Those are the kind of deals that people say, look, I know I'm giving away a piece of my copyright, but they're giving me money, and they're going to help me make a record that might make something happen. So the trick is the ins and outs. Literally, if I'm getting into the deal, what am I getting? And if it doesn't work out, how do I get out of the deal? So when people talk about the ins and outs, that's literally, what they mean is what am I getting into and how do I get out of it if it doesn't work out? And that's the kind of stuff that the lawyer would help you with. But again, you have the internet these days. There's plenty of books out there, and you can Google any question on the internet, and you can probably find out the answers to a lot of, at least to give yourself the concept of where things stand. I mean, that's the best you can hope for, is kind of just to have some information because if you don't want to do the deal, then there's no point in talking to a lawyer about it. But if it's something that you think, hey, this could be good, I would still recommend that you talk to a lawyer and let them look at the actual thing you're going to sign, because that's what it comes down to. Once you sign that piece of paper, you've now made a deal. And if you make a bad deal, you may be stuck with it for a long time. So just be aware. And like I said,
All right, Wallace, thank you so much for coming in. We're approaching an hour now.
Okay.
This was really helpful. Oh, there you gone again. Okay, there you are. What's your website for everyone to know again?
Yeah, it's just my name. It's www.wallacecollins.com, or you can just Google Wallace Collins, and there's LinkedIn and Facebook.
And if you guys need an introduction. If you need an introduction, you can email me and I can introduce you to Wallace as well, so that'll work. Again, thanks so much for doing this for us here at Tunedly, and
sure,
great to have you with us.
Yes, hey, thanks, Chris, and thanks everybody. Hopefully I gave you some good information, and good luck. And like I said, don't sign anything other than an autograph unless you have a lawyer look at it for you first.
Got it. All right, thank you.
Okay, take care, guys.